of the speakers, and then we will proceed with the speakers themselves. So Katarina, please, the floor is yours.
Thank you very much, Maria, and good morning or good afternoon to everybody who's joining us from different parts of the world. Thank you very much for joining International Law Talks today. My name is Katarina Busova. I'm a Ukrainian international lawyer, and today within our International Law Talks webinar series, we will speak about a very poignant issue of sanctions. I would like to remind you that the International Law Talks is the discussion which aims to bring together the top Ukrainian and international specialists to discuss different international law issues which are of relevance to Ukraine, but of course which also contextualize these issues within the larger international dynamics, and so inform both the local Ukrainian colleagues and our international peers. We are run thanks to the support of the Media Initiative for Human Rights, and with my great colleague Maria Tomak from the Media Initiative, we are moderating this session. Also thanks to the support from the Helsinki Human Rights Union and the USAID Human Rights in Action program. I should say that if you would like to listen to the Ukrainian version of the webinar, you can do so by choosing the translation button, the globe in the bottom right corner of your screen, and please choose the German version. Unfortunately, there is no inscription for Ukrainian, so please choose German and you will hear the Ukrainian translation. Otherwise, the original discussion will be in English. And also, please feel free to post your questions to the speakers either in the chat function of the Zoom or in the commentary section near the Facebook stream or the YouTube stream of our discussion. And as I already mentioned, we are speaking today about the issue of sanctions, which are such an important tool for countering and preventing grave human rights abuses, grave corruption schemes, and other violations. But of course, due process is very important, and it's so important for the sanctions not to be cancelled by the decisions of domestic or international courts. And it is the issue of the design of the sanctions and their compliance with human rights law that we will speak today. And I would just want to point out that within the last 2 days, Ukraine hosted the EU-Ukraine summit, and their final resolution, the concluding resolution, which was actually published today, specifically mentions the issue of sanctions, and that the EU again extends its economic sanctions on Russia until Russia fully complies with the Minsk agreements. So our discussion today is really, really topical. I give the floor to Maria, who will introduce our brilliant speakers, and we will then proceed to the discussion. Thank you.
Thank you, Katarina. I would like just to mention and to add to the context that actually there's currently a huge issue, in particular in the frames of the Crimean platform that was started and launched by Ukrainian government recently, the issue of the domestic legislation, Ukrainian domestic legislation on sanctions. And we have the law on sanctions, but it's really bad, just to be straight and forward. And we are talking a lot about how we can amend this legislation. And moreover, Ukrainian state does recognize this problem, and there's currently an interdepartmental task force on the amendments to the sanctions legislation. And luckily, we have today with us Alexei Makeyev, who is co-chair at that task force, and he will probably, hopefully, share some of the details on how this task force is working now and what's the result of its work. But anyways, there's no clear sanctions policies in Ukraine, and I'm really thankful to the experts that joined us, that are joining us tonight, just for sharing their opinions, because it's kind of priceless for Ukraine, because US has like a great experience on sanctions policies, in particular when it comes to sanctions related to human rights, but also UK has I would say, recent experience with Magnitsky Act-like legislation, and it's great that we have experts from both sides of the Atlantics with us today for them to share their opinions. I would like to introduce the speakers finally. Sorry for this long introduction. So today we have Ambassador Daniel Fried, who is an American diplomat and one of the architects of the United States sanction system against Russia in particular. He served as a coordinator for sanctions policy at the US Department of State, and currently he is a Weiser Family Distinguished Fellow at the Atlantic Council. I do realize that I can go on with the introduction of Ambassador, but today I think that your competences are the most valuable. Thank you. Also, we have Megan Smith with us. She is a human rights lawyer at the London-based NGO Redress, and she is advocating for the effective use and enforcement of Magnitsky sanctions in the UK, and she supports other NGOs across the world who would like to file their submissions to the UK government. And also, we have Scott Johnston with us. He is a staff attorney for human rights accountability at the Washington-based NGO Human Rights First, and Scott coordinates Sanctions and Accountability Coalition, a group of over 150 NGOs that try to use Magnitsky Global Magnitsky Act in order to designate the perpetrators. And I'm happy that our organization is a member of the coalition as well. And also, we are joined by Alexei Makeyev, who is a representative of Ukrainian MFA, and namely, he is a special envoy for sanctions, special minister's envoy for sanctions, and he is co-chair of the group that I mentioned previously. So without any further delay, I would like to give the floor to Ambassador Fried, and I would like just to ask you some specific questions before you start your speech. I mean, you have this great experience in sanctions policies, and maybe some general question is what are those factors or things that the government has to bear in mind while working upon the sanctions policies, especially when it comes to the Russian Federation? Because of course, for Ukraine is a key challenge and maybe something that we need to consider. And also, maybe you can comment on the issue of specific body on sanctions, because now it's been debated in Ukraine whether we need some specific body that deals with sanctions policies and what are the benefits and what are the drawbacks possible. And in that context, how to make the work of other institutions that are engaged in the sanctions policies process, like Ministry of Justice, etc., to efficiently coordinate with that sanctions policies body. Thank you.
Thank you for the invitation. This is a serious group, and I'm honored to be invited. To answer your question, the key policy issue with respect to sanctions is always this: what is it you're trying to achieve? What is the purpose? So the purpose of the sanctions are to get Russia out of Ukraine, out of the Donbass and out of Crimea, and those are two related but somewhat different issues because Russia has claimed Crimea and it doesn't yet claim the Donbass. But the purpose is to get Russia out of Ukraine. But Russian aggression against Ukraine is not limited to Crimea and the Donbass. We are also seeing a ramp up of Russian pressure on Ukraine using energy. And I'm thinking of Putin's threats just a couple of days ago that something could happen to the gas pipeline running through Ukraine. This is a threat for anyone who knows how to read Putin. There is also the question of other forms of Russian aggression against Ukraine that are similar to its aggression against other European countries and the United States: cyber attacks, infrastructure attacks. So there are a lot of vectors of Russian aggression, but the principal purpose is to get Russia out of Ukraine. Now, as we look at the deployment of US, European, UK, and EU sanctions, there are lots of ways to divide them up, but one way to think of them for the purposes of this discussion is to look at them as in different layers. One layer is what I would call sanctions maintenance and enforcement. That is, making sure that the existing sanctions don't get stale or don't erode because of lack of attention. So, for example, who's doing business in Crimea in violation of the US, European, and frankly, Ukrainian sanctions? Find out who they are and go after them. Remind people that the sanctions regime is real. During the Obama administration, we did this on a regular basis. We updated and refreshed the sanctions to account for new ways Russian companies and individuals were finding to evade the sanctions. That's not an escalation. That's maintenance of existing sanctions. A second layer might be increasing the pressure to convince the Kremlin to negotiate seriously using the Minsk formula or another formula, but to negotiate seriously. They're not negotiating seriously, they're playing games. Should we increase sanctions on Russia to get them to negotiate? Well, this probably should be tied with a diplomatic effort to intensify the negotiations. And you can do it with an existing framework, or you could change the framework, or you could have the Americans open up a bilateral channel to support the existing framework. There are pro and con arguments on both sides. You notice that Undersecretary of State Tory Nuland is in Moscow. She knows the Ukraine issue well. The Russians have attacked her for her role, pretending that she was somehow responsible for the revolution of dignity, which is nonsense. But let's see what comes out of her discussion. So that's a second layer of sanctions. The third layer of sanctions is to respond to increases in Russian aggression. Okay? And let's not kid ourselves, this is a real possibility. Something in the Black Sea, right? Something like the Sea of Azov, except this time maybe in the western part of the Black Sea. Or some attack on the Ukrainian gas pipeline that Putin just threatened. Like, we have learned that when Putin makes a threat, he may later act on it. Okay? Let's remember that. The we in this case being the US, UK, Europe, and Ukraine, need to be prepared to respond immediately to new Russian acts of aggression. We should not find ourselves in the situation of discovering that the Russians have done something and then having to decide among options or create options. That's nuts. We know perfectly well that Putin is capable of further aggression. He has signaled he has hinted at the possibility of further aggression. We need to be ready now. And the best way to deter Putin from new acts of aggression is to be ready and to let the Russians know that we are ready. You don't have to be a diplomatic genius to figure this out. We did this a lot during the Obama administration, working very well with the Germans, the EU, the Poles. We had sanctions escalatory steps prepared, and we let the Russians know that we had them prepared in a way that was credible. So those are the three. Now, there are other ways to discuss sanctions, but these are some of the ways I'm thinking of. Now, Ukraine, let me say something particular about Ukraine's role in sanctions. Look, Ukraine is not a major world financial center. Okay? The sanctions in Ukraine are limited. They will block sanctioned individuals from doing business in Ukraine. But one of the values of Ukrainian sanctions is not just the harm the sanctions do themselves, but it is also a way for Ukraine to encourage the EU, US, and UK to impose similar sanctions. Ukraine has one big advantage. It knows the Russians. It has very smart people who can do the research and find out what's going on in a way that is harder for non-native Russian speakers. Like, Ukrainians understand the Putin system, better than anybody except Russians actually living under it. So I would be very interested in serious private discussions. If I were in the US government, I would be very interested in sitting down with the Ukrainians and discussing possible targets to prepare escalatory options, to find out what's going on, which leads to my second to last point. You talked about how the Ukrainian government should structure itself. Look, Ukrainians know better than any American how to do it. I will say that I found it very useful to be the sanctions coordinator because I had sufficient rank that I could actually go to Kyiv or go to Brussels or Berlin or Warsaw and sit down and have these discussions with an interagency team. I would travel with the Commerce Department, the export licenses, with Treasury that does financial sanctions, sometimes with the NSC. My job was abolished when the Trump administration came in, but the Biden administration is recreating it. And they have nominated Jim O'Brien, a senior, wise, experienced diplomatic troubleshooter. He doesn't know sanctions, but neither did I. What he has and what I had is the rank and the contacts to be able to make the system work. He'll hire sanctions experts on his team, but that gives Ukraine somebody to talk to, and therefore Ukraine should have somebody for him to call. Now, who does he call in Ukraine? He can talk to the foreign minister, that's great. When you're done talking to the foreign minister, then you need to go and talk to the person who's actually doing the work. And whether that's, Alexei Makeyev, Vitayu, or someone else is not my business. But it's really useful to sit down with Ukrainians so the Ukrainians understand what the American thinking is, what the European thinking is, and so we can get lined up. There is nothing better than pulling together options so that Putin isn't dealing with a disparate set of players that are sitting on their hands, but people who are ready to deal with his aggression. All right, my last point is humanitarian aspects, especially with respect to Crimea. Our policy should not be only punishment. It needs to be outreach to people in Crimea. And that means we should make sure that as we consider sanctions, we're talking to human rights groups. What do we do? What do we not do? Now, sometimes look, I like working with human rights groups. Sometimes I find it frustrating to work for lawyers for human rights groups because lawyers want guarantees that nobody's going to give them. Which strikes me as odd because human rights groups take chances all the time dealing with dictators. Surely they can take some chances dealing with OFAC, which does not, in fact, go after human rights groups. They don't do it. But we ought to be sitting down and talking with these groups in a serious way. What do you need? What should we not do? What should we be sensitive about? Never forget what it is we're trying to achieve. This policy is going to have to be sustainable for a long time. One of the good things the Trump administration did was issue the equivalent of the Wells Declaration, the non-recognition declaration about Crimea, that we're never going to recognize it. And it was modeled on the Sumner-Wells Declaration of non-recognition of Soviet occupation of the Baltic states. It was a really good move. It was inspired by my old colleague, Kurt Volker, who knew exactly what he was doing. He was locking in the Trump administration and future US administrations. So we were prepared to not recognize Russian occupation of Crimea for years or decades if needs be. And everybody thought it was useless in the Baltic states to continue non-recognition, and it turned out to be the right policy. We need to supplement non-recognition with outreach to people there. All right, I've gone on too long, and I apologize, but these are really interesting issues. I thought the Ukrainian sanctions list that came out in March 23rd of this year was a serious document. It was well researched. It was good to see that there were knowledgeable people putting it together, and I look forward to working with Ukraine in the future. But you really should look forward to working with Jim O'Brien, the sanctions coordinator, if the Senate confirms him. So, дуже дякую.
Thank you, Ambassador Fried. And just for the purposes of the clarification, I would like to ask you two short additional questions, maybe not so short, but still important. When it comes to the efficiency, I think that we are all agree that our ultimate goal is the occupation of the Ukrainian parts of Ukrainian territory by the Russian Federation, but is the fact that sanctions does not immediately bring us to that result means that we should not impose the sanctions. So in this case, how do you measure the efficiency of sanctions? I think that it's like maybe a philosophical question more than practical, but still, what's your opinion on that? And another specific question is regarding the sanctions against Ukrainian citizens that are imposed by Ukraine. It's a very controversial issue here in Ukraine, but you are totally right when you say that Ukrainians know Russia well, but also we have many people who literally support the Russian occupation of Ukraine, but for some reason they cannot be persecuted by Ukrainian, using the Ukrainian criminal legislation by the law enforcement. So, and sanctions seems to be the instrument, like the convenient instrument to signal them that they're doing something wrong. So, I mean, from your standpoint, is it appropriate at all to sanction our own citizens?
Well, okay, I'll do your first question first about effectiveness. It's not philosophical, it's practical, because the Russian propaganda machine is putting out the line that sanctions don't work and therefore we better abandon them and just get along with Russia. And there are some in Europe, and I fear some in the United States who will fall for that bad logic. So we need to explain, and we need to understand ourselves how sanctions have been effective and where they have not been. Okay, sanctions did two important things. First of all, they were strong enough that, combined with the Ukrainian resistance in the summer of 2014, got Putin to pull back from his claims of far more territorial aggression in Ukraine. He was planning to annex about 40% of Ukrainian territory under this Novorossiya theory. He backed off of that because Ukraine resisted and because the West resisted through sanctions. That was an important success. Secondly, the sanctions convinced Putin to acknowledge in the flawed but still useful Minsk packages that Ukraine that the Donbass belongs to Ukraine. He didn't concede that with respect to Crimea, but he did acknowledge it with respect to the Donbass. So that's what sanctions did. They have also succeeded in hurting the Russian economy. The estimates vary, but a lot of economists say that the sanctions hurt the Russian economy by about 1 to 1.5% of GDP per year. That adds up to quite a bit. They also, the sanctions on military technology are also, some experts tell me, hurting aspects of Russian military modernization. This stuff is real. I remember that the Soviets used to say that Reagan's economic pressure against the Soviet Union had absolutely no effect. We laugh at the pressure, and they were laughing all the way to the point that the Soviet economy collapsed. Now, it wasn't because of Reagan's sanctions. It was because of the dysfunctionality of the Soviet system combined with Reagan's and Western sanctions, and Carter's sanctions for that matter. So this is not a philosophical question, it's an important point. Sanctions aren't enough, but what do you think Putin would have concluded had there been no Western sanctions? Yeah, you think he would have stopped in the summer of 2014? He would have assumed he could keep right on going. Ukrainian sanctions on Ukrainian citizens. Oh man, don't, an American should not be in the position of telling the Ukrainian government what to do with respect to its own citizens, okay?
I mean, is it appropriate, for the US to impose sanctions on the US citizens? Would that have
We
been
usually
appropriate?
don't, well, we can, American citizens can get in trouble for violating sanctions. Yes, they can. Okay? You do not, an American citizen is not exempt that the executive orders on sanctions apply to American citizens. Therefore, you could therefore conclude that Ukrainian citizens are subject to Ukrainian laws and regulations. My only piece of advice would be that whatever Ukraine does should be free of any reality or perception of partisanship. Okay? And I think any of using sanctions as a way to punish political enemies. And I think you know exactly what I'm talking about. It needs to be clean. I didn't say no sanctions. I didn't say, that's not my place. It needs to be clean and devoid of partisanship. All right, that's my one thought.
Thank you, Ambassador.
Thank you very much, Ambassador Fried. And I would like to greet Mr. Makiev, who is the Foreign Ministry Special Envoy for Sanctions, and who is also the co-chair of the Interagency Working Group for developing the amendments to Ukraine's sanctions legislation, which Maria spoke about at the beginning of the webinar. Mr. Makiev will speak a little bit later about Ukraine's current stance with the sanctions policymaking and the existing draft laws. And now I would like to give the floor to Ms. Megan Smith. Ms. Smith is joining us from London. She is the human rights lawyer with the London-based NGO Redress. And Megan will speak on how to avoid human rights risks while designing the sanctions legislation and how to prevent further cancellations of sanctions by courts. And I would also like to draw your attention to the work that Megan contributed to on the financial reparations for survivors of sexual violence, because the next section of the International Law Talks webinars will be dedicated to the issues of transitional justice, of which, of course, reparations is a big topic, and of which also the particular treatment and the particular needs of the survivors of sexual violence is a big topic. So Megan's expertise today spans many topics, and I draw your attention to her work on reparations as well. Megan, the floor is yours.
Thanks very much. Thanks very much for that promotion and for having me on the panel today. It really is an honour to be speaking alongside so many distinguished speakers. As you said, so I'm going to focus on the human rights risks and issues which are inherent in sanctions regimes, in the design and then implementation of those regimes. I'm coming here with a little less specific Ukrainian experience, so I'm going to be drawing on the experience of the EU sanctions regime, which has been around for a while, and then the UK regime, which is relatively new following Brexit. I'm going to make specific reference to the UK Magnitsky-style regimes, which focuses on sanctions in relation to human rights violations. Before I get into the detail, I just want to make a few overarching points. As we all know, sanctions are a policy tool. They are not the result of or part of criminal or civil processes, but nevertheless, they operate within the framework of international law, and that includes human rights law. Now, what this means is that sanctions regimes need to protect the human rights of those who are sanctioned individuals and sanctioned companies. Those rights need to be balanced with the regime's policy objectives, whether that's tackling corruption, human rights abuses, or terrorism. Now, this balance is a really delicate one, and I think it's one that regimes all across the world are still grappling with. When I'm talking about rights in this context, I'm talking primarily about two sets of rights. So one are due process rights, so the right to be informed, to be heard, and to challenge measures against you. And then also where asset freezes are concerned, property rights. There are a few other rights which can be engaged, and I'll touch on them very briefly later. One final broad point I want to make is that it really is crucial that sanctions frameworks include protections of human rights. This shouldn't be seen as weakening sanctions regimes, as undermining the power or discretion of the state entities involved. Instead, human rights protections should be seen as a way to enhance the credibility and effectiveness of a regime. You just have to look at some of the instances at EU level to show that a failure to protect human rights, in particular due process, leads to numerous successful challenges, to the annulment of sanctions in some cases, and to criticism. So against that kind of broad background, I want to first talk about due process rights. I think the best way to do this is to kind of run through the process of sanctioning. So from considering listing all the way through to challenging and potential delisting. And as I go through, I will try and flag the human rights concerns and the ways in which those can be protected against. So let's start with considering an individual or an entity for listing, whoever that may be. I think the key question here is, what is the standard of proof that's required? What evidence do we need to show to get this individual or entity sanctioned? I think it's really interesting to note that one of the most common ground for annulment for sanctions at the EU level is a lack of sufficient evidence and reasons for the sanctions. And I think this just shows the importance of getting it right at the start. And I think as well, if part of the policy of the Ukrainian sanctions regime is to kind of encourage other countries to replicate sanctions, it's important to have this kind of real solid and robust starting point. Unfortunately, and rather unhelpfully, there is no international consensus on what the standard of proof for a sanction should be. In the EU, it's developed through case law, and it is a bit of a mouthful. It's a sufficiently solid factual basis to substantiate the reasons for listing. And that was developed by the CJU in CARDI 2. Again, rather unhelpfully, there is no agreed statement as to what that means. So it's kind of hard to develop a kind of real fundamental basis. I think the UK legislation is a little clearer and it's quite helpful. It says that there must be reasonable grounds to suspect that an individual or organisation is involved in some form of behaviour. And the UK Supreme Court has held that that's in line with international law. Now, the UK human rights sanctions regime has an additional protection, which I think is worth drawing attention to. The Secretary of State needs to also consider whether a sanction is appropriate. And when considering that question, they not only have to have regard to the overall policy of the regime to deter and provide accountability for human rights abuses, they also, and this is in the legislation, they have to have regard to any likely significant effects on the person designated. This introduces an element of proportionality into the assessment, and it's a way of balancing the interests of those sanctioned against the need for sanctions in that particular case. So then once someone has been put on the sanctions list, what's next? Well, I think it's very broadly accepted that sanctioned individuals have the right to be informed of the measures imposed on them and the reasons for those measures. They don't need to be informed before they are sanctioned for obvious reasons that can undermine the effectiveness of a sanction. But the approach in the EU and the UK is that they need to be informed as soon as possible after. Again, going back to the UK regime, and by relying on the regime, just to say, I'm not saying it's absolutely perfect, but it's a new regime and I think it's helpful to use as an example. The Secretary of State needs to give a statement of reasons, and those needs to include the grounds for which someone is designated. The statement of reasons can exclude information if they pose a threat to national security, international relations, or interests of justice. But the starting point is that individual needs to know why they are on the list. Then we come to challenging sanctions. And I think it's an unavoidable fact that sanctioned bodies and individuals do need to have the ability to challenge their inclusion on a sanctions list and the measures against them. I think it's really important to have effective judicial oversight. One of the key criticisms of the UN regime is that there is no independent judicial body to review sanctions decisions. And that's why so many of the UN sanctions are actually challenged at the EU and domestic level. In the UK, there's a two-stage procedure, which I think is quite interesting. So first of all, if you're a sanctioned individual, you can go to the government minister and ask them to vary or revoke your sanction. The minister has to take a decision as soon as possible and give you reasons. Now, the purpose of this first stage is to provide due process protections, but also allow for quick resolution. And I think that can be really helpful if your courts are overworked and under-resourced. But I think what's really important is to ensure that that government review is independent and there is no element of predetermination. It's a real re-review of the evidence and the facts. It's not just a tick box exercise. Then the second stage is a potential challenge in the court. So if the minister decides not to revoke or vary a designation, that decision can be challenged. And I think one of the biggest issues there is that sanctions obviously involve a lot of highly sensitive material. And that has often been cited as a reason why sanctions should not be reviewed in court. I don't think that has to be the case. So in the UK regime, we have what's called closed material procedures. So if there is highly sensitive material, the individual who is challenging their sanction was provided with an overview of what that material is to allow them to understand it, but only the court is able to review it in detail. So again, I think this is an example of trying to balance the due process rights of individuals and entities with the need to protect the national interest. We then come to the final point, which is an effective remedy. So if a court finds that an individual's rights have been violated, there has to be an effective remedy. In the sanctions context, that's normally delisting. And I think what's really important to emphasize here is that individuals or entities should not be relisted unless there is new evidence, a new criterion for sanctions, which they now meet, or if the due process violations have been corrected. So that was a bit of a whistle-stop tour through some due process rights issues. I'm just going to touch on two more things very quickly. The first is the right to property. And now that is quite clearly engaged when asset freezes are involved. There is quite a bit of case law here at the EU level, and the general point is that asset freezing measures are compatible with the European Convention of Human Rights, to which Ukraine is a signatory, as long as they are proportionate. And I think there are some key takeaways from looking at the case law. The court has found asset freezes to be compatible where there is a very specific and clear objective, where there are periodic reviews of a sanction. So in the UK regime, it's every 3 years. And when we talk about periodic reviews, it's really going back and reassessing the evidence. The sanctions are reversible, so there is a possibility of delisting, and that certain funds can be made available for the individual. And I think, that point's really important, to have a provision in sanctions regimes for licenses. So if an individual needs some of their assets for basic needs, for their dependents, for legal fees, providing that is a really important procedural safeguard. And then my final point, which I feel like I need to touch on, given the focus of redress, there is a risk, and it has been discussed over recent years, of evidence obtained through torture being used as a basis for sanctions designations. Back in 2012, Ben Emerson QC, who was the UN Special Rapporteur back then, found in relation to some Al-Qaeda related sanctions that intelligence obtained through torture had been relied on. So now the ombudsperson at the UN, who deals with sanctions relating to terrorism, will not rely on information if there is a credible and reasonable basis for an allegation of torture. And I think this is an approach that should be replicated on a national basis. It's really important that any allegations of torture underlying sanctions are proactively investigated. Thanks very much.
Thank you for all these details, Megan. It's really very important, I think, for us to know all that. And I would just like to ask you one small additional question regarding the, we know that in the UK Parliament, there is all-party parliamentary group on Magnitsky sanctions. I assume, so my suspicion is that it was just recently established, right?
Yeah.
Can you inform us, please? I mean, probably you're aware about the role of this group and what is the goal of this group? So, and what the competences are include, and whether they are dealing just with the Magnitsky related sanctions, or they oversee the sanctions policies in general?
Yeah, it's a good question. So this all-party parliamentary group has just been established. It's a little bit different. In UK Parliament, we have select committees, which are part of the institution of Parliament and have powers to call individuals for evidence. All-party parliamentary groups are more just a collection of MPs and members of the House of Lords who are interested in a particular issue, and they don't have any formal powers as such. But what they aim to do is raise awareness of Magnitsky sanctions specifically in Parliament and put pressure on the government to implement sanctions where they think that's necessary, and to improve the implementation and effectiveness of sanctions. And we're really lucky. We have some really high profile MPs leading the APPGs, Sir Ian Duncan Smith and Chris Bryant. And, you know, in the UK, there is a huge amount of cross-party support for Magnitsky sanctions between left and right political parties. So it's really about trying to build on that momentum and both assist the government and hold the government accountable in relation to, you know, implementing sanctions where we think they should be implemented.
Thank you, Megan. And now I would like to give the floor to Scott Johnston. Scott, I also have some specific questions to you, as your primary area of expertise is actually the GLOMAC and the human rights related sanctions imposed by the US. So my questions are as follows. First of all, what should be considered by the government or by the country who would like to establish some similar sanctions regime as GLOMAC, because it's something that was debated in Ukraine. And as far as I know, Oleksiy Makeyev is also one of the supporters of this idea of implementing something like GLOMAC in Ukrainian legislation. The second question would be whether sanctions and criminal persecution for the grave human rights violations can be combined from your point of view. Because again, it's very actual for Ukraine. Many of those people who are sanctioned by Ukraine are potentially can be targeted or can be persecuted as those committing war crimes and crimes against humanity in the occupied areas. So therefore, of course, we're like Ukrainian state is interested in persecuting them, first of all, with the criminal tools rather than just put sanctions on them. And third question is, how do you think sanctions related to human rights specifically can be measured? I mean, their efficiency can be measured. So we've been discussing some of the economic rates or economic signs that sanctions are working, that Ambassador Fried reminded us about. But when it comes to human rights, how can you measure the effect of sanctions? Because obviously human rights in Crimea, for instance, they are happening every day, and as well as in Donbass. But again, it doesn't mean from my point of view that those sanctions that were imposed are not efficient or not effective. So please, the floor is yours.
All right, well, thank you, Maria. I really appreciate the introduction and the opportunity to speak here today, and also for our longstanding partnership. We've always been really happy to have Media Initiative for Human Rights as part of the coalition, and it's been a privilege to work with you for many years now, and glad to be on this panel. one thing I just wanted to throw in at the beginning before I get into my short presentation, because I do want to keep it short so we have some time to have some substantive back and forth at the end. To Ambassador Freed's point about the recreation of the sanctions coordinator position, I just wanted to say I had at one point a conversation after the position was removed in the US. I had a conversation with a good colleague off the record from government who said that the Trump administration was promised to cut out the fat from government, but instead they cut out the key muscle that we needed to actually make our sanctions work. So I'm also very glad to see that position coming back, and I know it's certainly valued. Okay, so I prepared a few remarks that I think I can pretty well integrate all of your questions into. So I'm just going to hit on 5 points really quickly. So the first point is talking about what exactly it is that you're trying to achieve with targeted sanctions. This is also where Ambassador Freed started. I'm going to talk about this from a US perspective and what we've seen the US government do. And the US's answer to this question is always behavior change. And I think that's actually a really important thing to keep in mind. A lot of people come into the sanction space thinking that it's about retribution or criminal punishment, or thinking it's about deterrence. But really, as far as the US government's concerned, their main focus is on behavior change. How can you put in place sanctions that might actually result in people doing something differently than the way that they've been doing it so far? And they try to use sanctions as both a carrot and a stick, right? So it's a stick in that, of course, it's a major penalty being placed on you for having been involved in these abuses. But then it's also a carrot in the sense that, as Megan was talking about, it can be rolled back, right? So if you do change your behavior, it can then be rescinded. And so they try to play both sides of that in changing behavior. Behavior can, in theory, be changed really through 3 vehicles. So the first is through direct pressure on the perpetrator themselves, right? And these are the penalties that are actually put in place, right? So in the US context, those penalties are typically fourfold. So the first penalty is a visa ban, right? So they can't travel to the United States. A asset freeze, which is not an asset seize, right? They're not taking the assets, they're just freezing them in place. And I'll come back to that point later, right? So any assets that person has in US jurisdiction, they cannot access anymore. A prohibition on all US banks, businesses, and people from doing business with that person, right? Which, if implemented and enforced effectively, as Ambassador Freed was talking about, can have the effect of essentially locking those people out of the licit, the legal international dollar market, right? All dollars flow through the US eventually, inevitably, and people in the US cannot touch dollars that have been touched or used by those people. And then finally, through what the US government terms voluntary compliance, which is when banks, businesses, and people in other jurisdictions choose to not do business with this person, even though the US government can't force them not to, right? And typically they try to use political means, diplomatic means to convince other companies, foreign companies and foreign governments to stop doing business with these people as well, right? So that's the direct pressure. So you're trying to put all these different types of penalties on the individual to directly pressure them to change their behavior. Then you also have indirect pressure on governments, typically, this is especially true when someone works for or is a member of the government. We see oftentimes that, even though the sanction might be placed on a specific individual, the action that the US government wants to see happen is really on the part of the government vis-a-vis that individual. And it's not uncommon to see the US government implement sanctions and then have host governments of the perpetrator quickly follow up with a criminal investigation of that person's behavior, or follow up by removing them from the government office that they hold and replacing them with someone else, right? So this is a type of behavior change that we also see. And then finally, the last way you can try to achieve this behavior change is through naming and shaming these people, right? And it kind of this kind of falls into both categories, but this is an important issue that we talk about a lot from the human rights perspective. A lot of human rights abusers don't have a lot of assets that can be frozen, but it still matters. It can matter a lot to them to have a government like the US and increasingly other governments like the UK and Canada and the EU say to the world that this person is a persona non grata for in their country because they are involved in these types of heinous crimes, right? So these are the vehicles through which they're trying to create change. I'm going to move from that in my second point, which is that I just want to take a step back and make sure that we understand that the US government uses many different sanctions authorities. There's more than 60 different sanctions programs that have overlapping competencies. So I'm going to focus the rest of my intervention on specifically the Global Magnitsky Program, which is the US government's global human rights and anti-corruption program. But there are other programs that are directly relevant to Ukraine. There is a Ukraine program, and there are also Russia's programs that involve competencies to sanction Russians involved in the annexation of Crimea, and so on. So all this to say, the US government sanctions for a lot of reasons, not just for human rights abuses and corruption. And depending on the situation or the crisis as the US government sees it, they can implement targeted programs that are specifically tailored to a certain issue. They actually have done that in the context of Ukraine. Okay, so my third point is about what human rights abuses are actually sanctionable and what are the standards. So this is going a little more into the side that Megan was talking about. As Megan said, there isn't a global standard about what is a sanctionable human rights abuse, but what we do see with each country deciding for themselves is that there is some amount of consistency on what the US government terms serious human rights abuses. There's a certain amount of consistency around the concept of sanctioning for human rights abuses that involve physical violence against victims. This is sort of a common theme that we see through a lot of the sanctions. So abuses that involve torture or involve extrajudicial killing or involved enforced disappearance or involve arbitrary or prolonged detention, right? So we tend to be seeing more in this way. I should back up and say that the European Union, when it implemented its program, did take a broader approach in theory in terms of bringing in, allowing them to sanction for things like, repression of freedom of religion or repression of freedom of expression. But it remains to be seen whether or not they'll actually ever implement on those grounds in practice. So in sanctions that we have seen typically revolve around this sort of narrow definition of the types of sanctionable abuses. What are the standards in the US for sanctions? In the US context, the legal standard that the US government uses is a reason to believe based on credible information. That sounds like a low standard, I think, on its surface, but there is a certain level of threshold that has to be reached. And as far as what the US government tells us, they're not willing to sanction anyone under the Global Magnitsky Program unless there are two independent, credible sources of information that can corroborate the same facts about the abuse and also the responsibility of the perpetrator for that abuse. I know that the US government takes challenges to its program to its sanctions really seriously, but also the US government has a really wide national interest exception that it can invoke for these types of cases, and that's not true for every country. So it's really to Ambassador Fried's point, I can't really say exactly in the context of Ukraine what Ukrainians should do, but you certainly should be sizing up what the standard should be based on how challengeable it is in Ukrainian courts. The US government's position is that it never wants to lose a case, and in the context of GLOMAG, it never has lost a case in court. So I think that's sort of the baseline that most governments should be shooting for. Pivoting to my 4th out of 5 points, I just wanted to track back on the concept, Maria, that you had talked about earlier about sanctioning Ukrainians. In the US context, I think it's important to understand that sanctions are seen as an administrative law program, not a criminal law program. And under the Global Magnitsky program, it explicitly says that it only applies to foreign nationals. So there isn't necessarily a direct vehicle for sanctioning US persons through the Global Magnitsky program. Now, the lawyer in me would tell you, well, there are some sort of back ways that you could hypothetically sanction a US person, but the point is the most direct interpretation would be you can't under the GLOMAG system. And more importantly, we've never actually seen the US government do that in practice. I think that the US government's position is that anything that could be sanctioned under the program is also simply illegal for a US person to be involved in. So if a US person were to be involved in any abuse for which they could get sanctioned, the US government could simply bring a criminal case against them in US courts, right? The idea of sanctions is that it's a way that you can get at people who are beyond your jurisdiction and influence their behavior and try to change it, right? We have a criminal system to go at people who are within US government jurisdiction. This can also tie into your question about criminal prosecutions. So in the US, we've seen the standard for sanctioning, that reason to believe based on credible information standard, is lower than the standard necessary to bring a criminal case against someone, right? And this is because it's an administrative function. It's also lower than the standard that you would need to reach to seize someone's assets, right? To actually take their assets, which is why they can only freeze their assets. But what we have seen the US government do, which I think might be of interest to you, is a partnership between, so the Treasury Department and the State Department run the sanctions program, but then they partner with the Department of Justice to do what we refer to as freeze then seize strategy for sanctions. So a good example of this that we saw in the case of Yahya Jammeh, who is the former president of the Gambia, is that the US government sanctioned him in 2017, which froze his assets. And that includes a multi-million-dollar mansion that he owned near Washington, D.C. So it was frozen. He couldn't sell it. He couldn't transfer title of it. It had to just sit there. And then just last year, the Department of Justice had taken its time to build a comprehensive case that could rise to a higher threshold of evidence. And then they announced last year that they were bringing a civil forfeiture case against the House, right? So to be able to actually seize the house from him and the benefits from it. So those types of partnerships do happen and can be really effective. Final point is, I think as Ambassador Fried said, I think he's exactly right that about the advantages and disadvantages Ukraine have, right? The disadvantage being it's not a major financial center that's going to have a lot of financial clout through sanctions. The advantage being within the region, it's a really key player that has really important knowledge and understanding. And I think that there's a real potential here for Ukraine to be leading out on human rights sanctions within its region. Multilateralization of sanctions, right? So cooperation between governments is becoming an increasingly important push. The Biden administration talks about it a lot. We recently had a conversation along with Redress with UK government officials who told us this is going to be the key focus of the coming, of the coming year for them, is working on building up multilateralization. Canada has effectively said they're not doing it unless they can do it in cooperation. And the EU is also obviously interested in this. Earlier this year, we saw for the first time ever all 4 of those jurisdictions sanctioned together. in the context of Xinjiang abuses, which is a big deal. I mean, not only is it a big deal to see the international cooperation in all 4 jurisdictions coming together, but with sanctions against, officials of a country as important in the world as China, I think that sent a really strong message. But I think there's a space here for Ukraine if it joins in and becomes part of this community of global Magnitsky sanctions to be leading out regionally and showing the rest of these countries, what they think, what Ukraine thinks are the key perpetrators who should be designated and the key strategy to move forward towards a more prosperous Ukraine and more prosperous region, a more peaceful resolution to issues with Russia. And the last thing I'll say is that, local input is important. I think that's true in the context of Ukraine being local to the region as a government, but local input is also important in terms of civil society having a part in this. And I genuinely think that one of the primary factors that has led to success in the Global Magnitsky Program is that it explicitly mandated that the US government had to consider recommendations from credible civil society organizations when it was making its sanctions determinations. And so I hope that in the Ukraine, that type of provision is also baked into your laws. Thank you.
Thank you for this comprehensive presentation, Scott. Thank you so much. And I think it would be a great ambition for Ukraine to become a regional leader in terms of sanctions for dictators against dictators in our region. Probably you know whom I mean. First of all, it's our northern neighbors. And here I think it's a great place to give the floor to Alexei Makiev, who is actually representing the Ukrainian government. Alexei, thank you for joining us. And I would really love to to know your opinion on those presentations that we've just heard, and maybe you have some additional questions to the experts, but also can you tell us about actually what is going on with the developing of the amendments to the Ukrainian legislation, whether that task force that you co-coordinate is working now upon some proposals on the amendments, and also what do you think about this idea of Ukraine being like a leader in the region in terms of sanctions policies?
Thank you very much, Maria and Katerina. Thank you very much, dear colleagues, for giving me those ideas. I cannot show you my screen, computer screen right now, but I have around 2 pages of ideas noted there. For about more than 1 year, as I've been appointed by the Minister of Foreign Affairs, Special Envoy on Sanctions inside the Ministry of Foreign Affairs. First, I played the role of sanctions coordinator inside the ministry, just to make the things right in how the procedures on different aspects of sanctions are functioning inside the Ministry of Foreign Affairs. After that, I jumped out of the MFA area of responsibility and took the leadership in the interagency group on the new legislations on sanctions, because the way sanctions function today in Ukraine is not efficient, and I would like to have different ministries cooperating together in order to make this very important security and foreign policy tool as efficient as possible. I would not join the usual approach of many politicians who claim the leadership, the regional leadership or world leadership of Ukraine in doing sanctions. But my ambition is to bring Ukraine into position of a responsible player in the sanctions landscape, together with our key partners, with the US, with UK, European Union, and Canada, So my ambition is to restructure the way sanctions are prepared and imposed here in Ukraine. And my proposal would be my proposal to the leadership of the country and to different ministries inside the government and to human rights activists and NGOs is that we start building here in Ukraine from the scratch a new body, which might be named as a National Sanctions Bureau, which would pull all the strings together and coordinate the activities of different agencies and ministries, and to make the process of sanctions designations more streamlined. Just today, I appeared some 15 minutes later after you started your discussion, and the reason for that was that I was invited to the foreign minister, and together with the state secretary, we discussed and decided that from next Monday, I will not be alone anymore in the Ministry of Foreign Affairs, but there will be a new department formed in the ministry, Department of International Security and Sanctions. So I will have 11 people. Well, actually, it would be on Monday, it would be 11 chairs, not people, but someday there will be 11 fighters to support me in bringing these changes to the whole system. And I'm about to make the case of the Ministry of Foreign Affairs as a showcase for other ministries in the system, so they introduce into their rules of procedures the need to deal with sanctions. This, by the way, was one of the results of the interagency working group sessions. So every ministry is tasked to introduce into their rules of procedure, special procedures on how they deal in preparing and implementing sanctions. And some ministries would also nominate vis-a-vis of me, those special representatives or envoys or people tasked with preparation and implementation of sanctions. So my ambition is that everything works as in a Swiss watch, and I'm honored to inform you that both the US government and the UK government and our colleagues in Brussels are supporting me. It could be that what we create here in Ukraine might be perceived as a role model for different sanctions regimes, because we start from the scratch, and this is why I'm now just sponging all the ideas you presented today, so we make our own legislation more efficient. And this is where we are. I appreciate very much your ideas on different reasons for listings. I'm not a lawyer myself, and this would be part of the job of my new team. So we start thinking about listing a person from the position on how will we defend the case if it is challenged. And I think this is a completely new way of looking on sanctions, not just to be able to hold the line while protecting the decisions of the government, but also to exclude the possibility of violating the rights of the people, the human rights. And I appreciate very much the the idea of creating a clear mechanism on how to challenge the sanctions or to review the sanctions. Just for your information, recently there was a case that the wrong person was listed by our decision, and this person had nothing to do, was the name and the surname fully corresponded to the name and surname of a person in Crimea, but instead it was one of the practically colleagues of us who got sanctions just because of an error in the identification. And in our 2-day system, it costed us some 3 to 4 weeks to correct an error because of the bureaucracy. In these very cases, I appreciate, Scott, your ideas on how it might look like, going to the minister as a first point, right? Just to challenge and to review sanctions would be one of the possible solutions to that. And in case of the Magnitsky legislation, this is also our ambition. My personal persuasion is that Ukraine needs to play a more active role, and for our country, for Ukrainians who are now suffering from all those heinous crimes against our citizens in the occupied Crimea and Donbass. I think we might play a more important role in human rights violation prosecution and protecting human rights globally. At the end of the day, we diplomats and government officials, we are working in name of the people, and this is something I hope would be part of Ukrainian political culture and DNA, protecting human rights and doing policy for our citizens, protecting the citizens. So this is where we are. I will take your ideas and advices, and we will do our homework. I would really appreciate very much any assistance of NGOs in this complicated job, and I suppose that we would need to talk through together with you, Maria, especially on how to do and how to implement into Ukrainian legislation the main ideas of the Magnitsky law. So once again, no ambition to be a leader, but taking the case from the position of a responsible leadership, I'm sure we will succeed.
Thank you so much, Alexei. I'm really happy that our conversation is very practical for you, and you have at least 2 pages of the notes which are going to be used. And it is indeed a breaking news. I already reported it to my Facebook page that we are going to have the Department on Sanctions and International Security. Sorry, maybe I was too fast, but I could not I could not do anything than just to report it to the wider world. And I would like now to give the chance to Scott to comment and to respond to the question.
If I'm not gonna be fired till Sunday, that would be okay.
I'm sure that, but we will say our word that you have to remain within this position.
Okay.
And the event has been live streamed anywhere on YouTube and Facebook, so Maria's announcement was not that first.
Well, thank you, Alexei. I'm glad, as Maria said, that this has been helpful for you. I just wanted to quickly respond to the specific question you asked me about what it looks like for a minister to review sanctions, and the anecdote that you shared about the incorrect designation. So in the U.S. system, when someone is designated, they are allowed unlimited administrative appeals. So they can send as many appeals as they want to the US government requesting that the sanctions against them be removed. The US government says that they will do fresh consideration of every appeal that presents new information, right? So if you just keep sending the same thing over and over again, they will review it once and they won't review it anymore. But every time you send new information, they will review it and consider it and make a determination whether to maintain or remove the sanctions. There are fundamentally 3 grounds upon which you could argue that sanctions should be removed. So the first is, to your anecdote, I'm not the person you wanted to sanction, right? And that does happen. That's happened in the US context before as well. That's why today the US government maintains that at an absolute minimum, they must have the person's full legal name and their date of birth to be able to sanction them. They will not sanction them with less information than that. And ideally, they would like to have even more. And when you see US sanctions come out, they oftentimes will include the person's address, their passport number, but basically they just need to have enough information that banks can correctly identify this Scott Johnston to be sanctioned and this Scott Johnston that can keep using their bank account, right? So that's the first challenge that you can do is you have sanctioned, you sanctioned me incorrectly. The second one is I am the person you wanted to sanction, but I'm not guilty of what you have accused me of doing, right? And then they would have to try to present information to the contrary to show that they're not responsible for the abuse. And then finally is you can say the third option is I am the person that you tried to sanction and I am responsible for what you sanctioned me for, but I have changed, right? I have done what you've asked me to do or wanted me to do to modify my behavior, and thus I shouldn't be held accountable in this way anymore. So I'm happy to follow up on that more, but I think hopefully that was a helpful answer for you.
Thank you.
Thank you very much, Scott. And it's really a pleasure to see how the discussion feeds into some practical implementation, because Scott previously has been speaking about this importance of the civil society and state cooperation in the design of the sanctions. And of course, thanks to Maria's post, I'm sure there will be so many professionals and the activists from the civil society field in Ukraine are willing to join Mr. Makeyev's new department. So we'll follow those developments closely. And colleagues, I have a question to you, and this is the question that also came from a member of our audience about the connection between sanctions and prevention. Prevention is one of the core pillars of transitional justice and generally is a very important pillar of the security system on the one hand. On the other hand, of course, we spoke about the due process guarantees and substantiation of the sanctions, that they should be based on the solid evidence that a person has contributed to a grave human rights violation or another misconduct. How far do you think the governments or international organizations could go in designing the sanctions to prevent the possible escalation of the existing abuse or the abuse that is quite might happen quite probably? Perhaps Ambassador Fried, could you comment on that? And then Megan, from a legal perspective, you could comment on that, please.
Well, are we talking about abuse that comes from a government, from a subunit of a government? Policy answer default mode is it depends, but it really does. If you have, I was responsible for implementation of the Magnitsky Act when it first came out, because it was, nobody wanted to touch it at the Department of State, so I figured, why not? And we were dealing, the Magnitsky Act covers individuals responsible for human rights sanctions. And if you judge that they are responsible for a given sanction for the torture of somebody or a gross miscarriage of justice, that's an individual. If the human rights abuses are because of the actions of an entire government, and I'm, let's say the persecution of Alexei Navalny, okay? That involves individuals, but it also involves Putin. He's almost certainly making those calls. Then the question is, if you want to prevent further abuses, and the repression of Navalny is related to Putin's steadily increasing authoritarian control, moving into totalitarian territory, then you have to ask yourself, at what point do you not go after individuals? At what point do you go more systemically? And this is not easy. Okay, those are tough issues. It's not just Russia. We have the US government and sanctions practitioners in and out of government have to make these judgment calls all the time. When are you going after individuals that are doing bad things? When do you go more systemically? And then, and I'm thinking of Megan Smith here, do broader economic sanctions risk hurting people? Okay, to say that there's no dilemma is a dodge. Of course there is. All right, let's be serious. But sometimes you've got to make that choice. So those are not easy calls. I should say, just for the record, that Scott Johnston talked like somebody who's actually been responsible for sanctions, and his points were spot on accurate. I don't know whether he worked in OFAC, but I suspect so. The US government hates losing cases and very rarely, if ever, does. Therefore, the evidentiary standards for individual sanctions are high, and they should be high. They should be high. There should be just an aura around sanctions that you can go to court, but you'll lose, because OFAC prepares its packages with diligence. Now, when we did Magnitsky Act recommendations, we set ourselves a very high standard. We never accepted information from an individual source. Bill Browder, let's be honest, come on, is active in this space. But he was known as having, an agenda. You can agree with him or not, but he was known as having an agenda. Therefore, the rule I set down is you cannot act on the basis of information you've received from Browder or his organization. You have to have independently derived corroborating information. And people used to complain because it meant a lot of work. And I said, no. We never want to be in the position of being accused of acting at the behest of someone who has an agenda. I'm not saying it's a bad agenda. Okay, Browder makes very compelling cases, but you can't be acting at any one person's, you've got to have broad enough sources that no one can question the integrity of the process. And that means it's slow, and that means it's difficult. But that means when we come out with somebody, we stand by it. And even then there can be mistakes. This is not the place to talk about Deripaska. He deserved the sanctions, no question about it. But there were unintended consequences that were embarrassing, that we hadn't seen. It wasn't my decision, it was US government after my time. And the US government had to walk it back. He's still under sanctions, but a complicated story. I mention it because even when we do due diligence, there are unintended consequences and it gets complicated. And for Alexei Makeyev, the new, is it director of the new sanctions, I don't know what your title will be in Ukrainian, but one, congratulations. And two, you'll be able to work with Jim O'Brien and the Europeans, but Jim O'Brien's a good man, an experienced, solid, A-grade professional, a political appointee who has worked, a Democrat, but he's worked with Republicans and, very, absolutely straight, he's nonpartisan in the way he thinks about problems. I can't recommend him too highly. You'll enjoy working with him.
Thank you, Dan. We know each other for ages, and I will stay as a special envoy, special coordinator, because I have a role model just sitting in front of me, and this is you, Dan.
Well, good luck, and work with the Brits and work with the EU. And you don't need me to tell you, I mean, the Swedes are great on this. The Poles are wonderful on all these things. But you know this. You've got a lot of friends.
Thank you.
Thank you very much, Ambassador Fried. And Megan, could you please also briefly comment on the correlation between sanctions and their potential role for prevention? And then Maria will close our discussion.
Yeah, sure. I'll be super quick because I'm conscious of the time. I think sanctions do have a preventative role. It's interesting that in the UK Magnitsky regime, the purpose of sanctions is to provide a deterrent mechanism as well as accountability, which I think is slightly different from the way in which sanctions have traditionally been thought of. And so I think there is that preventative power. There's also provides a way to prevent perpetrators from using their assets to continue to commit violations. That's particularly so in the role of enablers of individuals or companies who are financing particular human rights abuses or are involved in corruption. But I think we'd get into very murky and difficult waters if we were sanctioning people based on purely on prevention rather than on what we can prove that they have already been involved in. I think sanctions need to be based on historical current action rather than kind of the prospect of involvement in certain activities.
Thank you, Megan, for this brief answer. And while we're limited in time, unfortunately, and I really appreciate that you dedicated 1.5 hours of your time to this webinar and to bringing your ideas and your perspective and your experience, which is very, very important for us. I would like to thank you all. Thank to Ambassador Fried, thank to Megan and to Scott, and of course to Alexei Makeyev for joining this discussion. And I'm sure that all of the ideas that were here today, they really can be utilized and used by the Ukrainian state. And for us, this expertise is really very important. And thank you so much again. And hopefully we can stay in touch and further, and maybe you can give some advices and further to Ukraine while we develop the sanction